Now I am going to dictate a legal passage based on Kolkata High Court judgments on criminal matters part 2 at the rate of 120 words per minute. Let's start. The scope of preliminary inquiry is not to verify the veracity or otherwise of the information received but only to ascertain whether the information reveals any cognizable offence within square bracket also available at 2015 within bracket 2 CLJ within bracket Cal 141. Stop para. A careful scrutiny of the oral testimony of the ocular witnesses overwhelmingly established that the appellant committed such offence on the spur of the moment. From such a momentary impulse on the part of the appellant, it cannot be held that the appellant committed that offence of murder within the meaning of section 300 of the Indian Penal Code. Rather, it can be construed that the appellant committed the offence with the intention of causing such bodily injury as was likely to cause death within the meaning of section 299 of the Indian Penal Code. Stop para. In the context of section 439 of the code, the 1988 amendment to the code in the state implies without any ambiguity that the expression court of session in inter alia section 439 of the code includes a court presided over by the additional session judge in a subdivision. The 1988 amendment, and particularly the first provision to section 9 within bracket 3 of the code, covers not only appeals and application as referred to in the impugned notification of section 22 2011 and the letter of September 6, 2014, but also takes within its fold cases and proceedings in the criminal courts in that subsection ... The weight of the authority vested in additional sessions judges by the first provision to section 9 within bracket 3 of the code has to be viewed in the light of section 209 within bracket A of the code also being covered thereby. If the accused is unable to furnish the bail as directed by the magistrate, then on a conjoint reading of explanation I and the provision to subsection within bracket 2 of section 167, the continued custody of the accused even beyond the specified period in para within bracket A will not be unauthorized, and therefore if during that period the investigation is complete and the charge sheet is filed, then the so-called indefeasible right of the accused would stand extinguished. Stop para. Since the husband of the opposite party number 1 is a co-sharer of the undivided dwelling house in question, the ratio of S.R. Batra and another versus Srimati Toruna Batra reported in AIR 2007 AC 1118 is not applicable in the facts of the present case. The very process of penning through his lordship's own signature by the honorable companion judge was effected when his lordship had become Panctus officio. It is apparent from the facts available before us that such a penning through was not a spontaneous corrective measure occasioned by an inadvertent error. If that was the case, there ought to have been recordal of that factor in the subsequent opinion in the form of an order dated 7th June 2016, and the matter ought to have been listed on that date. It is impermissible for an order to be passed on a day the matter is not listed and the parties having no alert over a fresh order going to be passed in petitions already disposed of. In any event, there cannot be two orders of two different judges of a division bench in the same set of matters on two different dates. Such a course defeats the very objective of having a division bench in exceptional cases. If such a course is to be adopted, the reason should be disclosed in open court for withholding the order, and such a reason ought to be incorporated in the court records. This did not happen in the two petitions from which this reference originates. Legally impermissible course was adopted by the honorable opinion, judge to revive jurisdiction over matters which was already lost. Stop. Thank you.